Justice, where are you? Michael and Linda are here.
Love you, Linda.
The world is justice. Will we ever find justice?
The courthouse the other day in the hallway, you're singing
Will
"Oh
we
Happy
know
Day."
justice when we see it? To be and down, may I lead the way. Hoping justice will win the day. Listener clues, finding justice where we can. Join us now, we're on the run. Justice is waiting, we'll see it done.
Oh, I forgot to do that, didn't I? There we go. Thank you so much. Thank you, Missy. It's been a long day already. Hey, welcome to Justice Hoof TV. Michael Bryant here, and I've forgotten her name, but I'm
back.
Oh yeah, her.
I'm back. I'm wearing my
Her.
Christmas. Look at this, Justice
Let me
Hoof
put you on the
TV.
proper side. There we go.
Yeah, I'm sitting on the sofa. I'm so relaxed from being, I don't know, working.
Yeah, that happens. Okay, before we get into what we're here for, which is the Aidan Kearney hearing, you may have heard of Aidan Kearney. I'm not sure. Tell folks what you can about what's been going on. Go ahead.
I can't say much because I am an officer of the court. I can also only say that I was in Atlantic City. I was in Atlantic City with my co-counsel, Darren Gelber, and my client, Aidan Kearney, was part of a matter in Atlantic City. And I'm going to refer you to his morning bus stop this morning show. And I think that he was able to say what he was able to say, which is new. But I am going to keep the minimum right now. We go back on the 18th of December. I have a hearing in federal court on the 17th of December, a hearing in Atlantic City. So they're sort of in the southern part of the state, but I won't be with you either of those days. It's what I'm trying to tell you. Well, for some reason, all my court scheduling is now just clumped into the holidays.
It happens. So
federal court, it happened because of the shutdown, is what's going on with federal courts. So the federal courts are getting back into speed with their civil cases.
Okay. So I shared basically what you just did about the Atlantic City situation, referred to what Aidan said this morning. So we're clean. And that's where that is. So quit begging people for more detail. Hey, I was back.
I'm not going to give it to you. Yeah,
I was back and forth this morning with Norfolk County because I had requested 3 weeks ago to not just carry this Zoom, at the time it was not a Zoom, but to be the pool camera. Never responded, nothing. So this morning I resent it saying, hey, I'm resending this, but now it's a Zoom. So we're just saying, I basically was saying, I'm going to Zoom, I'm going to stream this. So, and all of a sudden I'm getting responses from people. Hey, and I said, why didn't you guys respond 3 weeks ago? What's the deal?
Right.
Anyway, I just finally got, and this is from, I'm going to have to do some research on this. As we know, Jennifer used to be the head muckety muck up there, and then she just disappeared, and Erica got involved, and Erica got us the credential, right there, has her name on it. They referred me back to Jennifer Donahue. And so she sent an email.
Jennifer? Jennifer?
I assume, and this, so I get an email. This came in at 11:30 this morning after the back and forth. Hi, Mr. Bryant. As a member of the press registered in accordance with the SJC Rule 1:19, you may live stream broadcast the Zoom hearing scheduled for 12:05. That said, FTR remains the official record of the proceedings. What's FTR? I have no idea what that is, but who cares? So anyway, I didn't care whether we were pirating it and doing it as outlaws. We were going to do it because we had done what we should have done ahead of time. And just because they got their heads up their rear ends and finally got around to it, I'm sorry, too bad. But we're okay. We're in. We're going to have it. I see the logo is up there. Missy is on it. So as soon as they open up that camera, we will
open up. I know we're going to go on just one little minor thing because I want to tell our viewers and something. I have not yet, but I will next week immediately get to the Canaro papers to get pressed, although the Supreme Court has not ruled. That's a New Jersey case scheduled for January. Supreme Court hasn't ruled on the warrantless search, so the likelihood of it going in January is slim to none. But we are going to have who's going to apply for his press credentials with our graces, with our making him a member of our press, and this is going to be a surprise to you too, is Darren Gelber.
Oh, good. Great.
We'll be able to cover it because he's in the county above it, which is he lives actually in Monmouth. He works in Middlesex. And so we will have, if I can't do it or you can't do it, we will have a correspondent on
Cool.
the scene.
Cool. Yeah, and we looked into just the basic application in Jersey. Probably not a surprise to you. It's ridiculously
Oh, it's going to be fine.
cumbersome.
I have the
They
names of
have
everybody, but I have
they
the
have
names
what's
of everybody
called
now. We're good.
it's called the Society of Professional Journalism,
Mhm.
SPJ, and it's a very, I'll be honest with you, a pretentious group.
Wait a second.
Believes
We've already got the papers to ask if we want to become the pool camera. I don't want to become the pool camera.
no, that's what I'm saying. They
Yeah.
again, it'll be worked out, but
It's fine.
yeah,
I love New Jersey. I love New Jersey.
I
I'm a
think
Jersey girl.
I
Remember,
think
I'm
you
a
have to.
Springsteen
Yeah,
girl.
I'm more
Born
objective.
in the USA.
I'm
Okay,
more
I don't
objective,
sing well, but
and it's a pain in the ass, but I'm glad you love it. Okay, so we have these documents that just have
and
come
besides, it's a Monmouth County case. I'm a Monmouth County girl. Okay, I'll get off. I know I digress. I'm back.
circulating. Okay, so we went over the response in our members only last night to the Cosgrove belatedly filed response 8 days after the deadline. Not a word to anybody, just here it is. And then, by the way, court, new judge, Bezazazos, can we just file this late? And is there a problem with that? That'll be the first issue this judge has to deal with, and it will tell us immediately whether we can respect him or not. Because if all he says is, "Oh, well, there's really no prejudice to anybody, let's move forward," then we'll know he's taken, he's bought, he's on the grift. So we have that response from Bradel Betterow to the late filed response. Technically, I guess this would be a reply brief or a reply memo, but then Cosgrove even filed a reply to the reply, a response to the it's just ridiculous.
A
So we're gonna
reply.
yeah, we're going to look at, I don't know, whatever time we have, maybe minutes, but we want to at least look at it and get a sense of the position. Let me find the Betterow response here first. There we go. The Betterow reply. This is what they will, this will be, among other things, what they're talking about today. Remember, we're not even getting to the merits of the mega motion. We're just.
How does Cosgrove argue the mega motion if the issue for recusal of him is still there? I don't get it. I mean,
that's what the judge has two huge decisions to make. One is Betterow's opposition. Is it going to be waived? Is it going to be received? Is it going to be considered? Number two, is Cosgrove going to be in the mix? It's got to be, these decisions have to be made before you move forward. So let's just hit some of the high points here. And since I've not read it, I'll just kind of go through it until I see the feed come up. The Commonwealth's untimely response, and then we know what that means. I won't go to that footnote. We know it was 8 days late, is more noteworthy for what it fails to include rather than for what it does. Strikingly, Mr. Cosgrove ignored the elephant in the room. He and lead investigator Detective Lieutenant Bryant have been sued by the witness Lindsay Gaetani for the intentionally harming her during their prosecution of Aidan Kearney. Without more, the court should refuse to consider Mr. Cosgrove's submission unless the court concludes that he shouldn't be disqualified due to his conflict of interest. The defense detailed how former prosecutor Kenneth Mello impaired the integrity of the grand jury proceeding. One expects that the Commonwealth would oppose serious allegations of pervasive prosecutorial misconduct by including with a response to a detailed sworn statement from Mr. Mello. Was there that? I didn't see that. It's like everything they wrote in there was like, we can't even talk to this guy. There was a statement by Cosgrove that I never got all the information I needed from Mr. Mello because I wasn't able to go see him. You don't have a phone? You don't have email? You don't have some other way to contact this guy? Apparently not. And so why would they have a statement from Mello in their opposition? Yet rather than submit any sworn explanation from him, the Commonwealth provided woefully inadequate unsworn hearsay from Mr. Cosgrove, designed to justify Mr. Mello's misconduct. Acutely aware that Mr. Mello's too many to count errors before the grand jury impaired its integrity, the Commonwealth mostly ignored addressing his misconduct or case law supporting the defense. Instead, it urges the court to avert its eyes, nothing to see here, from the flawed grand jury proceeding by concluding that the defense waived this argument. As detailed below, the Commonwealth's preference for form over substance sought to mislead the court by ignoring binding precedent contrary to its position and by relying upon inapplicable civil practice rules. Point number one. Again, we're keeping an eye on the feed. When it pops up, we'll go. The court should not consider the Commonwealth's response unless it determines that Mr. Cosgrove should not be disqualified. I mean, that's going to be a preliminary question. The irony of Mr. Cosgrove's snarky criticism of the defense motions should not be lost on the court, given his failure to address the blatant conflict resulting from his prosecution of a matter in which Ms. Gaetani is both his accuser and a witness, and where her credibility will conflict with that of his co-defendant, D.L. Tully.
So who's telling the truth? That basically says, hey, Cosgrove, you've got to figure out who's telling the truth, Gaetani or Tully. Therefore, you have a conflict because you can't have two masters.
It couldn't be a more clear conflict. And that's why the third charge is now gone, and now we're down to two. And the same analysis is going to apply here. Although Mr. Cosgrove avoided directly confronting his conflict, he unwittingly illustrated why he must be disqualified. He believes that Ms. Gaetani is a witness who possesses information that is favorable to the case he is prosecuting against Mr. Kearney. As Mr. Cosgrove wrote, discovery provided by the Commonwealth shows that Gaetani was indeed a witness, emphasis added, interviewed by the police with specific attention to what she knew about Kearney's ongoing communication with Karen Reed. After that interview, she received a summons to testify before the grand jury. It's hard to fathom a conflict worse than one where a prosecutor/civil defendant concedes that a witness plaintiff suing him possesses information helpful to the prosecution. It is worse. Ms. Gaetani wasn't simply interviewed by the police. She was an important witness against Mr. Kearney, who was debriefed about the subject matter of the instant indictments by D.L. Tully, who just happens to be Mr. Cosgrove's co-defendant in Ms. Gaetani's lawsuit. Lest there be any doubt that Ms. Gaetani was an important prosecution witness, D.L. Tully relied heavily on her information to establish probable cause to obtain a warrant to seize Ms. Reed's cell phones, which years later, Mr. Cosgrove seeks to search. And that's still up in the air, that request to get into those phones. Mr. Mello instructed D.L. Tully to serve Ms. Gaetani with a grand jury summons, the purpose and timing of which has led the defense to argue that the investigation of Mr. Kearney was conducted in bad faith. In his overly sarcastic eagerness to ridicule this theory, Mr. Cosgrove unintentionally confirmed his conflict by emphatically agreeing that Ms. Gaetani is a relevant witness in regard to this matter. Here's something I'm annoyed about. When we went over this last night, even the font size and margins used by Cosgrove were annoying. He used a much smaller font size.
He didn't use 12 times. He didn't use Times New Roman 12?
No, he did not. And he's crammed a lot of cut and paste, single spacing. Okay.
Right, here we go.
We'll leave it alone and go inside.
Oh, shit. We're just letting everyone enter. Good afternoon. This is the Zoom for Norfolk Superior Court. This is Commonwealth versus Aidan Kearney, 23 CR 313, 25 CR 88. We just ask people to remain on mute, and if the parties could please identify themselves for the record.
Good afternoon, Your Honor. I'm Robert Cosgrove for the Commonwealth.
Good afternoon, Mr. Cosgrove.
Go ahead, Tim.
Mr. Bradley, you're muted.
Sorry, Your Honor. Hello, Tim Bradle for Mr. Kearney, Your Honor.
Good afternoon, Mr. Bradley.
And Mark Betterow for Mr. Kearney. Good afternoon, Your Honor.
Good afternoon, Mr. Betterow. Good afternoon, Mr. Kearney. Okay, folks, first time meeting, so let's have a brief before we get into the substance. I've noted from the docket on this case that there were already a couple of judges who recused themselves given past dealings. So I want to deal with that issue right up front and get that out of the way. I'll start with the parties first. I've never dealt with you, Ms. Betterow. This is the first time I'm meeting, so I don't think there's any reason for me to engage in any analysis under Rule 211 with regard to disabling prejudice. So I think we're clear on that issue.
We're good, Your Honor.
Excellent. I'm glad to hear that. With regard to Mr. Bradle, Mr. Bradle and I have known each other for more than 30 years. We tried cases against each other when he was with the Suffolk County District Attorney's Office, at least a couple, probably more. I don't remember, but there were at least one significant case against each other. During the time that he was a member of the defense bar and I was a member of the defense bar, we handled cases co-defendants, although cases went to trial. We certainly had a number of cases in which we represented co-defendants. at least through the motion stage. Outside court, we had a cordial, friendly, and cooperative relationship as members of the defense bar, but we did not socialize anywhere outside a legal setting. So given our dealings, I'm certainly satisfied that I don't suffer from any disabling prejudice with regard to Mr. Bradel. With regard to Mr. Cosgrove, when he was just Judge Cosgrove, I did appear in front of him a number of times. I really don't know how many times, but probably better than 25 or 30 times, I guess, as he sat in the various counties. I don't recall that he ever presided over trial that I did, but I know for certain that I did a number of motions to suppress and motions to dismiss with then Judge Cosgrove. There was nothing out of the ordinary in our relationship. It was purely a relationship between counsel and the judge at that time. We've never had any social contact except for in legal settings, and they're extremely minimal. Given that I took the seat that Judge Cosgrove, then Judge Cosgrove vacated, we were never colleagues on the Superior Court and never had any interaction on that level. And as I said earlier, we've never had any social interaction outside a few minimal contacts in legal settings. So I'm fairly comfortable in reaching the conclusion that I suffer from no disabling prejudice due to past appearances before, and certainly never did work with then Judge Cosgrove. With regard to the parties in the case, I've gone through the pleadings as much as I can. I've looked at the indictments. I've noted the names that seem to come up over and over. I'm familiar with none of these people. I've never met any of the civilians or interacted with them directly or indirectly who are involved in this case. As to members of law enforcement who are involved in the case, some of those names I have encountered, members of the state police, as well as members of the Boston police. I would add to that any dealings I had with them would have been as a criminal defense attorney, probably mostly seeking to undercut their credibility, but never had any personal dealings with them outside a courtroom. Certainly no social dealings with them. So I'm fairly comfortable in saying that I suffer from no disabling prejudice with regard to any of the parties who I've seen listed in the papers. The final issue, it is public knowledge that I grew up in Canton in the 60s and 70s and part of the 80s. I'm considerably older than all of the people involved in this case. So I didn't go to school with any of them, nor did any of the names, as I said, ring a bell for me. I lived in Canton, graduated from Canton High School in the early 80s, moved out for college, lived there intermittently through college and law school, and left there for the final time in, I want to say 1990, to the best of my memory. May have used it as a mailing address after that as I cycled through some post-college apartments, but have not lived there full-time since the early 80s and have not lived there at all since no later than 1990. I don't have any contact with the town in particular, nor do I have a prejudice for it, for or against any issues that might happen in that town, nor special knowledge thereof. So I'm comfortable in finding that I have no disabling prejudice as to my past associations in the 60s and 70s and early 80s with the town of Canton. So that being said, I'll go around the table and see if anybody has any problem with that, beginning with the defense. Any issue at this point with regard to disabling prejudice under 211?
No, Your Honor, and I agree with everything you said, and I appreciate the comprehensive rundown of everything.
Attorney Cosgrove.
I thank Your Honor for your thorough summary. Your recollection of our personal associations exactly coincides with my own. Having listened to your explanation of your associations with Attorney Bradel and your knowledge or lack of knowledge of the witnesses that may be involved in this case, I have no objection to Your Honor sitting in this case.
Okay, excellent. All right, so obviously I'm in Brockton. You guys are at different places. I'll give you my schedule going forward. Going forward, I'm assigned to Suffolk Superior Court. The first 6 months of the year, I'll be sitting in room 1008, which is a civil session. The second 6 months of the year, I'll be in room 808, which is a criminal session. I think at least for now, we'll work this out as we go forward, have a greater clarity as to how we can handle it. at least for now, for the next set of motions, which we need to get to, what we'll do is we'll do those in person in Suffolk Superior Court. What room that's going to be in, I don't know yet. The way Suffolk runs things, their civil clerks don't sit on criminal matters. There are two separate clerks' offices in Suffolk. They're very distinct in what they do. So either I'll bring the matter into 808 where there is a criminal clerk, or will perhaps be specially assigned to another courtroom. Sometimes courtroom 1309 is used as overflows. I don't know where we're going to be yet, but I can tell you that the next set of hearings will be in person in Suffolk Superior Court. So let's move on down the agenda. I touched base with Judge Krupp. Certainly didn't touch base with him on the substance of the motion before him, merely as to where he stands on the motion. Judge Krupp indicates to me that a decision is not immediate on that matter, but he does expect a decision sometime. I would expect this month before he moves on to his next assignment. I'm not going to promise that, but that's what he's been able to give me in terms of a time frame right now. So, assuming, well, let me just say this. If Judge Krupp denies Attorney Cosgrove access to the Reed cell phone downloads, then we really don't have to do anything more with that. The issue is concluded. If Judge Krupp allows access to the cell phones, where does that take us next, Attorney Cosgrove?
Well, if he allows access to the cell phones, that would mean that essentially he's allowed my motion, or allowed it in some modified form, to set up the taint team. That means the taint team is going to have to go through the cell phones, examine. We'll have to go through a process with the Reed attorneys as to search terms and so forth that would exclude attorney-client privilege material. They're going to have to report back to the court. The court is going to then have to hear from the defense as to the findings of the taint team. And then at that point, the Commonwealth would get the information as approved by the court to go through it. And assuming that it's relevant to Mr. Kearney's case, it would then be discoverable here. I would anticipate, well, candidly, we have been waiting for the results of the taint team on Mr. Kearney's cell phone for the better part of 3 months now. So I would say that either we would enter into an agreement if the defense is amenable, or if Your Honor orders that the Commonwealth forego the evidence of the Reed search in this case. It is, after all, a motion the search warrant is, after all, directed at finding evidence of a conspiracy case, but it would likely also produce evidence that might be relevant here as well. Or we would need to delay further proceedings here. Doesn't necessarily mean do nothing, but the case would be pushed back until discovery could be delivered to the defense, and they could make such motions as they feel appropriate.
Well, let me just ask you this. As I understand it, there's already been a download of the defendant's phone in this case. Is that correct?
There's been a download
I don't have sound from Mr. Cosgrove.
No, I don't know why we're muted.
Conspiracy to intimidate a
Oh,
witness.
here it is. I think it was an
Charges
accident.
Kearney here include intimidation of a witness.
Is he muting that? What is that little? I can't read what it says
I
there.
can't read what it says either. Now it's off, whatever it is.
Figures.
Let me put it to you this way. People operating technology in the courtroom, maybe there's something in the air this week.
That's the way it would go.
Oh, they're back.
We are interested in dealing with the disqualification motion first. Attorney Better filed a very comprehensive motion to disqualify Mr. Cosgrove. He's being sued by,
I'm going to come to that, Mr. Brady.
yeah,
Just want to make sure we understand the impact of Judge Krupp's.
sure.
Judge, if I may, that, and I don't want to merge the motions. I understand what the court is doing, but that disqualification motion also includes the investigation involving Miss Reed's cell phones, because it is virtually the identical conduct and the identical facts that are from the 2023 indictments. And again, without merging too much of this now, there is a disqualification motion on the indictments before Your Honor now, as well as the investigation that Mr. Cosgrove is doing, because the same witness who is at issue in the disqualification was a primary, or one of the primary sources that led to the warrant to go after Miss Reed's phones. So they are kind of intertwined. And if Mr. Cosgrove is saying, as he seems to be suggesting, that he can't predict the future in the event that he were able to search the phones, but if evidence were to be discovered and lead to a conspiracy indictment against Mr. Kearney, that implicates the disqualification issue. At this time, I'm unaware that Miss Reed has joined that motion, so I don't want to speak for what her counsel would advise. But to the extent Mr. Kearney is involved in anything to do with what we're calling the open investigation involving Miss Reed's cell phones, we think that the disqualification as it relates to Mr. Kearney needs to be dealt with in the first instance.
Well, I'll come to that. What I'm trying to figure out is if you agree with the timeline laid out by former Judge Attorney Cosgrove regarding what would happen in terms of next steps. Did that all make sense to you?
It did, up until the point where
I'll get to that part. I'm going to get to that. All right. Let's move on to the next issue. And I'll skip out of the order that I had in my agenda. The disqualification. I don't know, and I'm not going to prejudge it. It seems a little bit overbroad to disqualify Attorney Cosgrove from some other investigation. What I'm dealing with are the indictments that are before me. So to the extent that there's a motion to disqualify that's ripe, it would appear to be that it's on 23-313, not some future potential indictment. That may or may not ever come. And what Attorney Cosgrove chooses to do this time outside the indictments before me, I'm going to leave to Attorney Cosgrove. But I do think we need to deal with that issue sooner rather than later. And it does not appear to me that we would have to wait for the Reed cell phone extraction before getting to that issue. Would you agree with that, Attorney Cosgrove?
Yes.
All right. So how soon would we be ready to deal with the issue of disqualification?
Judge, I just wanted to throw out some dates if I could. January 12, 13, or 15 is what we're proposing.
Okay. Does that work for you, Attorney Cosgrove?
No, I'm out of the country on all of those dates.
Okay. How does late now, Mr. Brady, you've got some other business that's going to happen up in Essex County. You're scheduled for trial up there?
That's February 9th, Your Honor. That's correct.
How soon before that are you going to?
Your Honor, I could, give me a moment.
Hold on, Attorney Cosgrove. Mr. Brady, how soon before you become unavailable due to that trial?
Judge, I'm pretty flexible. I really don't want to delay the disqualification too much. I mean, unless Attorney Betterow has a different view, I'm thinking, can we do it a little sooner then?
No, I want to wait till I get to Suffolk
Okay. Oh, I understand. Maybe, is it, should we do, maybe the third week in January?
Let's see what Attorney Cosgrove has to say. What's good for you, Attorney Cosgrove?
That's fine.
Let's pick a Friday, late January.
That's the 23rd.
Attorney Cosgrove,
I can do the 23rd.
Mr. Bradle.
Yes, thank you, Your Honor.
All right, so we're going to mark that up for January 23rd. I'll be in touch with regard to time and place. I need to talk to Suffolk to see where they can accommodate me. I'll know that certainly by early January, what courtroom we're going to be in and what time. My inclination probably would be maybe a noon or a 2 o'clock hearing. I don't expect it's not going to be non-evidentiary, I take it, correct?
Correct.
Initially, at least, yes.
That's the way I read it. So we could probably get it in the afternoon. So it'll be either noon or 2 o'clock that will deal with that matter in Suffolk on, we'll call that 123 for now.
And I think, Your Honor, if I live to see another motion after your decision on the motion to disqualify, the next logical motion to take up would be the defendant's motion to dismiss the case.
That seems to be the right step to me as well. How does that sound to the parties?
Yes, we wanted to bifurcate the disqualification from that. Absolutely.
I think that's the right choice. Okay, so do we want to get that on the calendar now, or do we want to wait till the disqualification is done?
I think it makes sense to wait, but I'm at Your Honor's disposal.
We can wait because I'm pretty flexible when I schedule things in Suffolk. Okay, we'll wait on that issue. Between now and the 23rd, are there any discovery issues that I can assist the parties with?
Yes. We have been receiving discovery. We got some, I think, that we're awaiting that was mailed out yesterday. And we continue to get discovery in drips and drafts without, as far as we can tell, respectfully, any rhyme or reason. Some of the filings, Your Honor, will also see from the past several weeks, we're finding what are clearly discoverable materials from third parties, whether they be witnesses or potential witnesses in the case, whether they be other third parties who have made freedom of information requests, and they're getting actual documents that are directly related to this case. So we're just concerned about when does it end and when do we get with confidence everything. In addition to that, I believe Mr. Cosgrove, in his motion seeking an extension of time in late October, whatever it was, I think it was October 24th, indicated in that motion that the former special prosecutor on the case, Mr. Mello, had discovered or come into possession of things that he believed were quote unquote relevant. We're wondering what that is and when we anticipate receiving that. And finally, with particular emphasis on one important piece of evidence that was also contained in a filing from some time ago, one of the most important witnesses in the indictments, if not the most important witness, testified in the grand jury, alleged to a series of, I believe, threatening Facebook messages and family members receiving all kinds of nasty images and comments that she claimed originated from the client or someone else. That would seem to be clearly discoverable. That would seem to be something that clearly, if not in the Commonwealth's actual possession, is, coming from their star witness, would be in their custody or control. And we haven't received that.
I don't know who you're talking about.
Jennifer McCabe.
Okay. Mr. Cosgrove?
I will look into that as to Mr. Bettero's earlier point. The materials that I have just sent him, check is literally in the mail as of yesterday, and it should be received no later than Monday, if the post office can be believed. Does include materials that I received from Mr. Bettero notably a grand jury exhibit that they recently complained that they, I'm sorry, received from Mr. Mello, not from Mr. Betterow. Notably a grand jury exhibit that the defense has complained that they had never received, that was not in my possession or in the possession of the state police. And I finally managed to get it from from Mr. Mello, who had that particular exhibit. So they'll be receiving that and some other materials from Mr. Mello.
Okay. All right. Well, if there are particular issues that need to be addressed by the court, let me know. We can get together quickly in the Zoom and deal with it.
Judge, I think there are, and respectfully to Mr. Cosgrove, Mr. Mello seems to be the root of or a lot of these problems. And it seems to me what the Commonwealth can do is send somebody over to Mr. Mello's home or office and take custody of everything, so we don't have to rely upon Mr. Mello to discover grand jury exhibits from 2023 and 2024 being disclosed at almost Christmas time in 2025. They have the ability and resources to do it. We're entitled to this material. Waiting on Mr. Mello to provide discovery that shows up periodically doesn't seem like the best way to do it, respectfully.
Well, I'm going to leave the details of how Attorney Cosgrove complies with Rule 14 to Attorney Cosgrove. Just let it be known that he has to comply with Rule 14. If you don't, there can be sanctions. And I'll leave it at that. I'm not inclined to micromanage. I'm not going to micromanage how he complies, except to say comply. And we'll leave the details to the parties who are responsible. Okay. Let's assume the disqualification goes away. Let's assume that the motion to dismiss, the new motion to dismiss, is unsuccessful. Let's talk about the two indictments. How do the parties feel about joinder?
I think it makes perfect sense.
Mr. Bradel, Ms. Betteroff?
It's a little premature for us, Judge. We're sort of baking the cake right now, and we'd appreciate it if you let us respond to that on our next date.
Fine. I want to get started and sort of thinking about these things because they are
Sure.
all the same folks, and it seems like this case, in terms of evidentiary, the acts themselves, I want to speak for anybody, but they don't appear to be hotly contested. It's what they are is what the issue is. One says First Amendment, the other says witness intimidation. That's sort of my sense of what the evidence is. You can tell me I'm wrong about that, but
It's a very fair characterization, Your Honor. There's a bit more to do on the newer indictment. We don't have grand jury minutes even yet, and
I understand. What I want to do is I want to push that case as quickly as I can through discovery. So if we're going to do these together, let's do them. Mr. Kearney, is that the correct pronunciation, by the way? Kearney, not Kearney?
It's Kearney, Your Honor.
Kearney, I apologize.
Okay.
So look, I imagine he wants to get in front of a jury of his peers and be done with this. So my goal is to move us along as quickly as we can without skipping any steps. So let's get that discovery done. Now, how long do you think, if they're joined, is this case going to take? I'm not holding you to the time, but Attorney Cosgrove, how long do you think it would take you to put your case together in front of a jury?
Well, I expect that there will be, on behalf of the Commonwealth, a rather extensive list of prior or subsequent bad acts that I would wish to offer in evidence, as well as the evidence of the acts for which Mr. Kearney is actually charged. And depending on how Your Honor rules on that motion, would make a fairly substantial difference to the length of the trial. I would estimate offhand, we've got 6 or 7 victims, a lot of videos to show, 2 weeks maybe.
Sound about right, Mr. Bradel?
I think so, Your Honor.
when do you folks think would be a good time to try it? I'm not going to hold you to this. I just want to start sketching out in my mind when and how we're going to do this.
Judge, on the 2-week thing, are you saying full days or half days?
I'll go full days.
Okay, that'd be fair.
Any thoughts on when we could do it? The only time let me just block this out. I'm supposed to do an asbestos trial in June. That's going to take just about a month. So June is going to be out completely for me. So, work in terms of our calendars, just sort of scratch that one off.
Judge, it's a tough call in light of how much stuff we still have to do. It's a tough call. I mean, I could see this not going until the fall, mid-fall. There's just so many. This team stuff takes forever. We haven't even gotten any automatic discovery on the second case yet. We're still waiting for a grand jury minutes. There's a lot of extraordinary motion practice here. Disqualification, dismissal for extraordinary government misconduct. Discovery, as my brother said, is dribs and drabs. We have this prosecutor who's very ill, apparently, who's no longer on the case. He's been disqualified. Attorney Cosgrove's been disqualified from the 24 indictments, which have now been dismissed. There's just so much going on in this case. It's not your garden variety situation. And I think we really are realistically, if you want to put a cap on it, I think the cap has to be, mid to late fall, because we're just not going to get all this stuff done. It's been historically glacial pace.
I got you. And I don't have a problem with that. Mr. Cosgrove, how does that fit with your timeline and your availability?
Well, my availability is pretty open. As far as timeline goes, I don't associate myself with all of Mr. Bradle's comments. I agree with his bottom line. This is a complicated case in some respects with quite a bit yet to do and a lot of contingencies. And obviously, if Your Honor allows the motion to disqualify me, it won't be my problem, but that will certainly have an effect on the timing of any trial as well. I will say,
let me just slow you down for 1 second. The disqualification, as I can tell, is only on the 23 case. Is that accurate?
It is accurate, Your Honor, but if you disqualify me in the 23 case, it wouldn't make any sense, as far as I'm concerned, for me to try the one incident on the 25 case. I would respectfully ask the district attorney to relieve me of that responsibility.
Well, let's not go there yet. Aspirationally, let's shoot for a late October trial date. Does that make sense? Late October, early November?
That's fine, Your Honor.
Judge, I have a couple of murder cases. I'm not sure if that's gonna get it done for me. I have a murder case, the 5th. Could we go to November, maybe November 9th, 16th, December 7th? Any of those?
I can pretty much make those dates work. And I've checked with Suffolk, but we have flexibility here. Okay? So if that's what we're looking at, let's aim towards being ready. If it gets that far, let's aim towards being ready in mid-November.
Do you want to grab like a mid-November final pretrial, maybe Tuesday, November 17th, just throwing something out, and then maybe a trial date like Tuesday, December 1st?
Pencil it in your own calendars for that time. I'm not going to set the date yet because I need to confer with the clerk in 808. I don't have access to that docket right now. But pencil yourself in for around that time. And we'll this up once we get through the motion to disqualify, which will be on the 23rd. Okay, so, but let's try to work our way towards that date, and get this thing in front of a jury, and get it resolved, one way or the other. Okay. What else can we?
Sounds good, Your Honor. Thank you. I think that's everything on your agenda, Your Honor. I was following along on your scheduling order.
Mr. Cosgrove, anything else?
I just have one minor issue that I'd like to raise. It's not a big one. For some reason, Your Honor, Judge Doolin entered an order that all filings in this case were to be paper copies. I'm not sure why he entered that order, but I do find sometimes that when we are close to a deadline, I am close to a deadline, that taking a special run over to Norfolk Superior Court to deliver a paper copy is a lot less convenient than being able to do it electronically.
I would read Judge Doolin's order to be, a paper copy has to be filed. If you're up against a deadline and you have to email it in so we have it to prepare, that's fine, but a paper copy is going to have to be put in the file at some point. Look, if there's a deadline set.
If that's Your Honor's interpretation, I can certainly comply with that.
Attorney Bradley and Attorney Betterow and I have it.
That'd be a big help. I agree with it, Your Honor. Thank you.
But make sure a paper copy gets filed so that it, I'm not even sure that, Mr. Bradley, you can correct me because it's been a while since I sat in a criminal session in Suffolk. I don't think the Suffolk Clerk's Office takes electronic filings, do they?
No, they don't, Your Honor. Norfolk does, Suffolk doesn't.
All right. So right now this is a Norfolk docket. So you're going to continue to file there, but if you file electronically to the parties circulating the documents that way, that's fine.
Appreciate it. Thank you.
If it's a day late, it's a day late. You don't need to drive to Norfolk to get the paper filed that day. As long as it's electronically filed, followed by a paper file, that's fine.
Thank you, Your Honor.
All right. Anything else we can do today?
Not for the Commonwealth. Thank you very much, Your Honor, for your time.
So let me ask you one more question before we go. Are all the papers that I need for the disqualification motion filed?
No, Your Honor. Just a couple of hours ago, Mr. Cosgrove, I think, filed a response that, frankly, we had anticipated earlier, but we filed something addressing that yesterday, which I don't know if the court has seen or not. And Mr. Cosgrove filed something today. We've perused it. I believe I'm going to want to file just a brief reply in the next 10 days or so.
Brief reply. We have lots of.
I'll do my best.
Lots of paper already in this.
I may have an additional filing as well, but it'll be well within the 10 days that Mr. Betterow speaks of.
I know that the civil rules have already been brought into play here in the pleadings here, that they don't apply, but there is that motion reply, sir reply, and that's it. You can file what you need to file, but
yes,
it just doesn't. It's got to end at some point. All right. So file what you need to file. I want everything filed 10 days prior to the hearing. Okay. So no filings will be accepted on the disqualification issue unless there's new evidence after 113. Let's get this thing squared up and ready to be decided that day, or argued that day, decided shortly thereafter.
Yes.
All right. Anything else we can do?
It's good, Your Honor. Thank you.
All right. I'll as soon as I get to Suffolk and I have a better idea where we're going to sit, I will give you folks notice as to the time and as to the actual time of the hearing and the courtroom in which we'll be. That'll be an in-person hearing.
Thank you, Your Honor.
Thank you.
Mr. Betterow, do you intend to be there in person?
I will. Yes.
Excellent. Because Zoom is a little difficult when some people are hybrids are difficult. Let's put it
Yes.
that way. Okay. That's all we have today. Thank you very much. Margaret, you can close it up.
Thank you.
Thank you, Your Honor.
Thank you.
Bullshit. Oh, I'm sorry. I had a. You're still muted, I think.
Yeah, I'm so
You're still-
excited. We're going to Suffolk. I love Suffolk. I love Suffolk juries. That was Aaron Hernandez. It's Boston, right?
Yeah, but I mean, it's a joke. This is a joke, and this guy,
but-
the new
but-
judge, is no better than any
I
of the
don't know. I
others.
think he set a deadline. I
Zero.
think he
No,
set a
he's not.
deadline.
He's
He
just
set a deadline.
robes protecting
Yes,
the robes.
I
Oh, they
disagree
set
with you. I think
deadlines
he
all the
should have done it.
time. They're
Yeah, but
big
he's
on
going to
setting
follow through. He's
deadlines.
going to follow through with deadlines on
Oh,
this.
sure
He
we
can
are.
absolutely follow through. Yes,
Sure.
he is.
Sure.
Yeah,
I'm
I love
I'm not
Suffolk.
in the
Okay.
Kool-Aid.
And you know what's happening here? You know what's
Sorry.
happening here? There's going to be a new DA by November. This case is never going to
Yeah.
get tried. They're going to,
Well-
what they're going to do is they're going to try to go after, and excuse me, he's so disrespectful, Cosgrove. At least the judge asked Aidan, how do you pronounce your name? And he said Kearney.
Cosgrove is a
Cosgrove,
moron.
Kearney.
He's a moron.
Kearney. No, that is because he wants to disrespect Aidan. I can tell you that I've been in a court, and this is not revealing any secrets, where a judge did ask attorneys and did ask participants, how do you pronounce your name, and then honor it and follow it. Or if you correct them
You
because
mean
they
like-
make a mistake the first time,
Like
they honor it
civilized
and follow
people
it.
did? Oh.
Yeah, like normal
Crazy.
people that are respectful.
Crazy
Okay.
idea.
I mean, it's such a disrespect here. But you know what
Well,
they're going to try to do?
that's
They're
the
gonna try to
least
go
of
after
Cosgrove's
him.
problems.
Cosgrove's got a lot of
disrespect.
problems, but here's what the issues. They're going to try to go after Aidan Kearney in the next 11 months. That's what they're going to try to do in Norfolk County. I'm actually happy that this is, well, it's still a Norfolk case, but he's going to Suffolk with Judge, I guess it's Belezos. I didn't hear how he pronounced.
No, he
his
didn't
name.
pronounce his own name, but I've been giving it my best shot.
Okay. But he set a
be
deadline for the
Belezos.
argument. Yeah, he set a deadline for the argument. Tim Bradel seems to be very happy with him. Betteros seems to be happy with him. I'm extremely.
Of course, they're pretending to be happy with him, just
No,
like
they're
they're
not pretending.
on the courthouse steps. They're pretending to be happy with whatever the judge
No, I
does
think
because they
they're
have
absolutely
to.
happy.
No,
I think
that's
they're
just
absolutely
naive.
happy
That
with
is
it.
so
You and I
naive.
disagree.
No,
I'm not.
totally,
I am not naive.
They say what they
I
need to
think I am.
say. They say what they need
Yeah.
to say, and they have to be cordial and
yeah.
they're professional, and I respect that.
Bradel
I don't have
said,
to.
Bradel said the judge was going for June, July. Bradel said, no, let's give it an outside date. First it was September. Bradel's the one who said November. He wants November for a reason. Bradel's a very smart lawyer. Okay. Very smart lawyer. We're fighting nicely. We don't fight.
I don't disagree that he thinks it may be gone before then. I mean, it's the joke that, and I always get amused at people in the chat.
The judge
they
said
think-
he's going to dismiss it now. He said, you're going to argue this, Michael? You missed me, didn't you?
Yeah, there's people get all upset. You know, I can't believe this is the way litigation works. Normally, it's reserved for civil cases, but to see a criminal case this obviously kicked down the road for such ridiculous reasons is frustrating for everybody. But it's not unusual, especially in the civil world. But to see this unfold, and did we hear anything about filing late? Now, we'll get to that later. We'll get to that 6 months from now, or whenever we actually address the merits.
The bigger thing is this other decision about the phone downloads, okay, and the tape. That's the bigger thing here.
3
okay?
months.
I didn't like that judge. Okay, I didn't like that judge.
The Krupster. You don't like the Krupster?
I didn't like that judge. This judge, look, you get a gut feeling. I like this judge. If he were getting this case today, he handled it exactly as he should be handling it, and he is getting this case today. That's the problem because the way everybody else handled it.
But we'll
And
see.
if Aidan gets a Suffolk County jury as opposed to a Norfolk County
There will
jury,
never be a jury trial. But anyway, if he and why are we doing it in Suffolk? Because it's easier for him. Is that the deal?
no, he's getting assigned there. And then the way Massachusetts works is that you have to go where you're assigned, where the judge is assigned. But the Suffolk juries are great, Michael.
They're not going to have a
great.
jury in this case. It'll never happen. That's never going to
Well, then
happen.
that's
We
good.
know that.
That's good for Aidan Kearney if they don't have a jury, because that means the case is going to get dismissed.
Yeah, I think it'll be resolved before then. I'm talking about everything that has happened prior in the last 2 years and everything that now is discussed in today's context of just down the road with, I appreciate, yes, it's a new case. I've got to come in. I've got to evaluate things. So I give him a minor break for that, but he still has to enforce. You know, he said, what did he say about the rules about filing late? Anything that's filed late is not going to be
It's not going to be
received.
accepted.
Not going to be received. We'll see. We'll see, because he's already got the opportunity to look at something that has been filed exceptionally late.
He's getting the court for the first time. He's put this as a conflict.
He knows that's there. He knows that's there. He's seen these documents. He was even talking about how he's seen, opposition reply, sir, reply.
He said there's going to be no more. He said there's no
No.
more of that. No.
But you just
no
heard
more of that.
both Betterow and Cosgrove saying, "Okay, we got one more. We got one more each that we're gonna file on just the recusal, And I agree they should be separating that out.
But yeah, that absolutely should be said. The recusal should go first, but Cosgrove doesn't want the case if he can't try both of them. He, you know why? Because he wants to have everything together. He wants to put it all together, and he doesn't want to spend the time. So I think this judge may recuse him. Although, if he thinks
It didn't
that it's going
sound
to
like
delay
it.
although if he
Yeah.
thinks it's going to delay it, here's the problem. If he thinks it's going to delay it, because then they got to have another attorney. But who would you like to be trying this case against? Would you like to be trying this case if you're a defense attorney against Cosgrove?
Oh God, yeah.
Let me ask you that. Yes,
Of course.
So maybe
because he's incompetent. Of course.
Well, also you could bring up the whole idea of conflict even before
conflict.
a jury. Yeah, before a jury.
Sure.
Come on.
Sure.
I mean, you know.
And so it does put the judge in a weird position in that sense, because if he feels that delaying the case by replacing Cosgrove is an overall negative for those that are left hanging,
Right.
like Aidan Kearney,
Okay.
he then is put in the position of keeping Cosgrove, which may really not be in the best interest of justice because of the obvious conflict.
Right.
So the judge has an interesting decision to make there. Do you take the overall schedule to be more important than an obvious conflict with one of the
Because,
key
you know,
players?
The first thing that a person who's new coming to come and say, well, I just got put into this case.
course.
I needed an adjournment. I can't.
And now
meet
we're
these
talking
deadlines.
2027. Yes.
I can meet these deadlines. But then there'll be, I assume that the voters of Norfolk County are going to replace Michael Morrissey. That he's
And
not
so
going to be
you
running
think,
for re-election.
let's play that fantasy out.
Well, it's not a fantasy. Don't call me a fantasy. Just because
No,
you
it's a-
haven't had
it's a-
to deal with me.
A
Just because you haven't had to
fantasy,
deal with me.
a fantasy means wishful thinking. That's what the fantasy is. So your wishful
You
thinking
think-
is Morrissey will be replaced. So let's
No, that's
follow-
not my wishful thinking. My thinking is
not?
he is going to be replaced. And the question is, does a new prosecutor decide they're still going to prosecute? Or does this
Right.
do they kick this up? I don't know how Massachusetts work. Can you kick this up to the AG's office? That doesn't thrill me, because the AG's office has been like, where are you? Where are you? Out there? Is there a boat out there navigating those ocean waters?
I think if Morrissey is replaced
I made you laugh.
with somebody that's I don't know, honest, has integrity, is competent, then it will disappear. I do believe that. But I don't know that he's going to be replaced, because voters are idiots. So unless he steps down, I mean, look at I call it the Fondy rule. Look what happens in Fulton County. How many bad things could she do? And she's elected by 80% of the voters. Are you kidding me? Same thing could happen up there. Those folks are not bright. The smart people
Well, I don't
are
know about bright,
outspoken.
but
The smart
have
people
a
are.
bent.
But
They
there
have
are
a
a lot of followers up there that they just walk into the voting booth. Oh, Cosgrove. I mean, Morrissey. But there's a good one. DA Cosgrove. How would you like that? They see Morrissey's
It's not
name
going to happen.
on the ballot, and they just go, yeah, Morrissey. Yeah, that's the name I've seen forever. And I got 3 uncles that are in that family, because it's very
Yeah,
incestuous.
but he said he's
up
not
there.
running, right? Did he say he's not running? I think he said he's not running. I don't know.
Well-
I think it's right or something like that. I don't know. When is it filing? For those of you in the chat that are maybe from Norfolk County, when is the filing deadline? Anyone know?
I don't know. I could ask my friend. I could ask my friend Google.
Hey, it's
Mr.
times
Google.
like this- Times like this, keep Google close or keep Alexa close. But I turned my Alexa off.
I'm gonna see if I can get it here before somebody else does.
But I did like this judge. I mean, my initial gut reaction.
Yeah,
was
he's
okay.
just in a position where if he doesn't come across as a hard ass and make these guys follow the rules, he looks like a lackey. And everybody has seen lackey after lackey after lackey in Norfolk County. I'm getting there. Anybody give the answer yet?
Anyway, I mean, this should have been aware of the world. We should always have aware of the world is justice, right?
Yeah,
Where
well,
in
we
the
don't,
world
it
is
ain't
justice?
Norfolk County, I'll tell you that. This is a long query.
Okay, let's see. Are you typing the query out? Because if I were
I am,
typing it
the
out
whole
with my
thing.
nails,
Yeah.
okay, you all haven't seen my new nails. With my nails, because I know you've missed Fashion Friday since I've been gone.
Okay.
We still be typing.
It's a mess.
It's also very interesting. The whole
Filing
process-
deadline. Now this is August 25th, so of next year.
for
So you got plenty of time.
Wait,
Running for
where
district. Here it is. Here's my friend Google. Running for district attorney in Norfolk County. Filing deadline August 25, 2026. So a lot of time for somebody to come out of the woodwork.
August is the election is
August.
November, and you have until
Yep.
August to file.
That's what it says right there. Run for district attorney in Norfolk County. Filing deadline.
Holy moly!
So and it's
Wow.
106. Here, I'll give you some details in case you want to throw your hat in the ring there.
No, I'm not
it's
planning to move
reg-
to Massachusetts.
It's a regional
I
office.
really like
It's
it.
4 years. Wait, here's the tricky part. Commitment level, full time. Affiliation, partisan. Typical
Well, that means a
salary.
Democrat or
Yeah, and
Republican,
sometimes
right?
there will be like a county clerk job that is not affiliated with anything. They just run. Typical salary, 168,341 a year. Is this a runoff election? No. Is there a primary election? No. Filing period, it doesn't even open until May 12th. Filing period is May 12th to August 25.
Wow.
So there you go.
Wow.
And
A lot can happen in politics.
That's true for if you
in
want to be the Register of Deeds, if you'd like to be the Norfolk County Sheriff or the Treasurer or the Register of Probate. All of those fall under that same deadline, and you have to be at least 18. So, all righty. Filing fee is nothing.
It's a good thing to know that you could be the district attorney and can't drink. You have to be 18.
That's right. Well, the first thing you do is you change the drinking age. We're talking about Norfolk County. There is no drinking age there. It's anybody and everybody. And it's zero filing fee. So if you're indigent, you can file. Signature requirement, 1,000. So if you can con 1,000 people into signing you up for a petition, you're in. I think that might be a fun thing to do.
Well, you know what I would really like to hear. I mean, it'd be great if we can get either Mr. Betterow or Mr. Bredo on the show maybe next week or maybe Monday.
Yeah, we're working on it. We already anticipated that, so we're working.
You already anticipated that? Okay.
Yeah.
I'm glad you anticipated that because you know what? I'm back all next week with you.
Wow, all next week? Wow, crazy.
I don't, but the following week I do have, 2 lawyer, and then the week after, the January 5th week, starting that whole week, I'm gone because I'm in Harvard.
I think I'm in
Harvard.
Raise. That's what I think. I need a pay raise.
I know.
Something's going on here. I need to renegotiate my contract.
Poor Michael. You'll know that he's been taking the show from morning to night. He's been doing all the members only. I haven't even gotten back to who killed Stephanie yet. Although I am working on this because when I go up to Massachusetts, Paul Stark, who bought us that case, is still here. He hasn't gone back to Thailand because he had such an accident when a acetylene torch exploded on his hand that he is being, and he's a carver. So I plan to go to a place where he is and take questions with him, have a live show with him on what we found. But that'll be towards Christmas time, maybe between Christmas and January 1st. I have been working on that, just so you know. I have been working on things, okay, just so you know. But Michael deserves all the credit. He has been running the show from morning to night. Missy has been behind him. All of our mods have been with you. All of our mods have been with you. And he's doing all the different shows. He's running up, he's driving here, he's driving there. Missy's been streaming from morning to night. Really, this is great. And I see that some of you want me replaced. So, maybe I'll just make your wish come true. Be careful what you wish for.
Misdemeanor and Scott both and Scott McGinnis both chipped in to
they're both
try
great. They're both
try
great.
And fill your Laboutiers or whatever shoes you're wearing.
Well, I'm sure that we pay you so well.
Yeah, that's what I told Misdemeanor. So we're going to move you to the top of our guest host list. The payment, is. We can't really talk about it, but anyway, 5 Justice Serve TV memberships from Renee 83. Thank you so much. And again, I'll mention last night we had a members only that went very well. I appreciate everybody. We had people joining as it was on, which was very cool. And so next week we'll kind of pick up that new plan to do our little shorts, snacks, but do those live, and so members can take part. Let's look at a few questions that came in while this thing was unfolding. Melissa, Florida 407. Is it me or does this judge have him convicted already? What the heck? Now, I wouldn't say that. I would say if I were to guess on some of his decision making going forward, denied on the recusal and denied on the motion to dismiss. That's just my gut feeling, and not that would be unusual. in general,
No,
that,
and these things happen. That's usually the way the judges will say, let the jury handle it. Let's get to a jury to decide. But that's kind of
yeah,
scary, especially, and he put it right, the issue between the First Amendment, free speech, being a journalist, having free speech, being a citizen, and this ridiculous, in my opinion, witness intimidation, unconstitutional statute that if you are mildly annoyed by what happens, especially if you're a police officer, you're intimidated. That's not what the witness intimidation statutes are for.
yeah,
Simply
it's
not.
totally,
And
no, it's
well, you
abused.
know what you're having? You're having legislatures coming in with their issues, and they're putting in all these generic terms like annoy, and things like that, and then they're making it criminal. All right, so they're making it impossible for people to have a First Amendment because you live under this problem that maybe somebody will accuse you because Aidan's taken down the whole state police, as you know, in the Karen Reed case by this investigation. All right. They don't like that. People don't like people that take the whistleblowers down. They don't like whistleblowers. And that's why we have to support whistleblowers. You saw the same thing you're doing in the Long Island audit, right?
Yeah.
Case with our friend, right? Because the public does, but people in power don't. They don't want to be removed because they're in power, and power means money, and power means
Yes.
control.
Yes,
So,
it does.
I mean,
And
that's
power corrupts, and
my view.
absolute power corrupts, absolutely. And even in the
Absolutely.
case we have against Massachusetts State Police, it's the same thing. It was all based on First Amendment rights, which are trampled and stomped on there. So
That's your case, and that's it. And remember, we came into the Karen Reed case April 1st. I sat in my desk over at the other end of my office, and all of a sudden you were being harassed by Trooper Hardman. And I will say that because you've already filed that suit and you had to make a decision. Hey, we just got there. Do you want to walk it 5-6 times or, and you made the decision that the First Amendment was more important than anything. And we filed suit. You actually filed suit. You were the plaintiff along with Tom, CPU, and then Jason and some other people were on their other suits. But that was a very tough decision because then you would put yourself out there to be targeted. But you did it, and you're still waiting for a decision on that case, right?
yeah, it's still out there. But we did, and maybe it helped because of this. We got our press credential for what it's
Right.
for what it's worth. And so you
No,
do
it
the
was
right.
worth us streaming today. It was worth it. It was worth it.
Well, that
us
was a
streaming
whole
it.
different issue. We were going to stream it anyway, and I saw other people streaming it that I know for a fact.
Don't have a
for a
press
fact do not have a credential under 1:19. So is there going to be any? We were going to do it regardless because I think there's a First Amendment issue there as well. But if you're going to pretend to have this rule, now let's see if they go after anybody that didn't follow the rule. Then that person would have the opportunity to make a First Amendment claim. John. So we'll see if they do. We'll see if anybody does.
Because you have the right to go into the courtroom if you were there, if there were a courtroom, but there wasn't a courtroom. So you should have the right to go into the Zoom room. That's all.
Yeah. And just as they did out of Plymouth, as we recall, they handed out the Zoom information. There was no password. They're basically inviting the public to come in, but they were saying, no, you can't stream it. That's ridiculous. It's just crazy. So I think part of it is these established folks in the judicial system have no idea how technology impacts what they normally do. They don't know what seems to be right and what isn't. If you're opening up a Zoom to everybody, then why would you have a problem if somebody restreamed it? It makes no sense.
Right.
In fact, you're helping. So instead of having, I think that day, they had 900 some people in the Zoom, right? Well, if you allow it to be streamed by a dozen or so different platforms, you unclog the system. You're helping everybody. But I just don't think they're bright enough yet to know exactly what that all means.
I think that technology is a very difficult thing. I think in many courtrooms now they have people they can call in, the IT, who can help fix things. But I think that technology is a very difficult thing, especially of people, and I'll say that of a certain age. That it's almost like kids nowadays. They're born with the ability to speak 2 or 3 languages, and they're born with the ability to know technology. It's like it's in their DNA. But you take somebody who may be, my mother, if she were living, God rest her soul, would not be able to even get on a computer. It just wouldn't happen.
Yeah, that's the old fart rule, I call that. But the fact is, there are people that are older that make an effort to learn technology and to understand it. There are others that are just like, harumph, get off my lawn, and they just don't make the effort. And I think I
Well,
see
it's
that in
scary.
court
I
a
think
lot.
it's scary. I don't want to because I think it's scary and I think it's hard for a lot of people. And also, you go on technology, you have to buy a computer or a phone. You have to, or, your flip phone's not going to do it, right? So I think that it also is price prohibitive a lot of times, and all these different platforms. Think about it. 5 years ago, we didn't even know until the pandemic. No one even knew what Zoom was. I remember during the pandemic, someone said we could have a Zoom cocktail party. I said, what's Zoom and what's a Zoom cocktail? How do you have a cocktail when we're our house and you're in your house in different state?
Yeah. Well, since 2000, there's no doubt there's been rapid acceleration by necessity, that's the mother of invention, I hear.
Yeah.
Made of questions. I like that. Well, at least a judge, here's the other side, the other view. At least a judge has finally sacked up and told him to comply. I don't care how many people tell them to comply. That seems to happen a lot. That's the first time. No, I don't think so. I've heard a judge tell them it's time to comply. No, we've heard them say, here's the time. They just don't do anything when they don't.
No, I do agree with you, Made of Questions. I think this judge it was pretty stronger here. He doesn't want to embarrass him because he is, he did work with them, so to speak. But I think he wants to get this. He made it very clear this case is moving this year.
Yeah,
I think.
Meaning next year. Yes. Yeah.
Well,
right?
it was he wanted to get it in July. It was the defense who said we have to have all this other stuff being done.
And I know that Bradel, and thanks again to Renee 83, not only gifting memberships but becoming a member. Thank you so much. I think that Bradel's smart because he doesn't want to paint himself in a corner. Because the thing that was so glossed over, that is so frustrating, is this discovery that never seems to come out. It's 2 years now, and they don't have grand jury minutes.
Right. And the other thing was Mello.
For that?
I agree with you. Mello. He's absolutely right. Send somebody over to Mello's office, just like you would do a search warrant. I was about to say
what were you going to say?
Bad word. I was supposed to have bad word, a search warrant, and take the files and say, here are the files.
Okay, so
I'm not going to tell Mr. Cosgrove how to do his work. So that's
what I think was a perfect opportunity for him. I realize it's the first day in the chair. I get it. But it was the perfect opportunity for the judge to say, well, is it true that you haven't complied with this, and this, and Mr. Mello's been ill or whatever? Let's do this. You have 7 days to get that material from him. Send a U-Haul truck and a hand truck over there and get that material. He could have done that.
Trust me, if it were the defense, that would have been happening. Because being a defense attorney, that's what judges tell you to do.
Yeah.
You don't have it. You haven't gotten it to them. You, Miss Kenny Baden, have until tomorrow morning when I open the doors of this courtroom to get the discovery over to the other side.
Except they would have said Kenny Baden.
Yeah, they would have said Kenny
and then you would end correct her.
Yeah.
So that's my point about.
Or they would have said Baden and forgotten the fact that many of my cases are under Kenny.
Part.
Yeah.
So that again, it makes my point that the judge, he had an opportunity, a perfect opportunity. But again, it's you don't comply. Maybe by the time we have another hearing, we'll get what you need. And Cosgrove just eats that up and abuses the system going forward. And I'm just so tired of it. So tired of it. And that's why Bradel said, look, you can't handcuff us with a summertime date. These
we don't have discovery.
Douchebags don't even give us the material that we have a right to and have had a right to for 2 years.
And here's what I'm worried about. They're going to get these Scots or their phones. The grand jury already once found that Aidan, and for all of you who don't know, Aidan is now my client. All right. So I'm disclosing my conflict here in case you don't know. But the grand jury already said no indictment. They want to keep going at phones, and then what bothers me, because I don't trust the government, they can create things, okay, or have other things happen and create things by having this time, or create sometimes a conflict because of these statutes which are so broad, and because quite frankly, there's a lot of prosecutors I do trust. We deal with a lot of prosecutors' offices. Some are just incredible people, right? But then this one doesn't have my trust. I'm sorry.
Yeah, and they've earned your distrust, as a matter of fact.
And yours too, and all of our viewers.
Dr. Jen Toxic, or Dr. Jen, are you really a doctor? Or anyway, Dr. Jen Toxic, thank you for becoming a member. We appreciate that. Okay, what we have a question about what we should do. This is my question, raising my hand. Should we do like a recap tonight at 6, like our normal show, and kind of meet again with the folks who aren't, the daytimers who actually
I can't.
you can't do it tonight? You're busy? You're busy? Okay.
I
All
can't.
right.
All right, guys. It's been a very rough week. Okay. So I figured that normally on Fridays we tape a show, and then Michael had already taken care of it because he's taking care of everything else, including having his little red shirt underneath so he could match mine.
Yeah, I know that is
Just to
bizarre.
serve,
That was not
just
on
to serve.
purpose, folks. That was not on
You
purpose.
sure?
No.
You sure? So you can match
How would I know what
just
you
to
were
serve- There
wearing?
you go. Just to serve TV. There you go. All
Yeah,
right.
mine has no logos.
Well, that's your problem that you
How
didn't
would I
buy
know
a
what you were
brand new,
wearing?
that you didn't buy a brand new crop top, just to serve. I mean, because we're like in mind meld these days. We're in you've missed me so much. You're
That
melded
must
into my mind.
that must
Okay.
be it. So
How
let
many
me just
times have I
boil this
texted you
down.
anyhow?
Yeah, one or two. Not all that many, because I wanted to leave you to do your thing.
I
So
would
you
have
can't do tonight because you got an obligation, or you want to just take the night off. Is that the bottom line? Is that where
I
we are?
made an obligation
Okay.
because I assumed we weren't on tonight because I figured that you had already pre-taped Friday night. So I made an
Ah,
obligation because I'd been so busy working that I sort of made an obligation. If you get my drift, I kind of
okay.
even my husband has to stay home and take care of Tubi.
Oh my gosh, you're even dumping the doctor for the night. Wow.
I mean, he had Tubi. He's had Tubi. He was supposed to go testify in Philadelphia, and luckily his case got adjourned because they actually canceled court because they were worried about a snowstorm that never came.
Oh yeah, that happens a lot, unfortunately. But I understand, because the opposite would be the worst. To have people coming
That's
in
true.
and the
That's
place
true.
is the nightmare. The judge, even the judge in the Walsh case, had said early in the week when there was the storm. It's probably the same storm. She said, let's take a look at what's happening on Tuesday,
Yeah.
and maybe we'll just do a short day. And of course, she kept saying it's a nothing burger. The weather turned out to be a nothing burger, and so everybody stayed for the whole day.
It's usually the case. So no,
Linda,
I did not go to the casino. No, let me put it this way. You know how it broke my heart? Because first of all, I can say 2 points about a casino. First of all, while I was busy working all week, New York City has approved 3 casinos, 2 of which apparently are going to have poker rooms at least.
Wow,
But
yeah.
2 of them won't be ready until 2030. Okay. But one of them is going to be ready next March because it has to do with
What is that?
Resorts World, which is going to be in Queens, because there is a Resorts World Catskills that I do go play at, and that's going to have a poker room. They say it's come this March, so I'm very happy about that. Because except that I don't know why we wouldn't allow one in Manhattan, because that would be the best thing to do. But no, we're putting them, in the Bronx, and 2 in Queens, so they can kill each other basically, right? So anyhow, but I had to go to Atlantic City, and I was there for the better part of 2 days, and guess what? I never
Didn't
played
play a hand.
of
Yeah.
poker. I never even thought of the word casino.
You were gambling in a different casino, as a matter of fact, called
Well, when
Court.
I get when I'm committed, and I've said this to one of my girlfriends, is when I knew that I was hired and I would have to try a case, which I thought was going to be on Zoom initially. I do nothing. I don't even shop. Okay. That tells you how much and you're right. You didn't really hear from me, right? Because I am totally 100% focused on what I have to do in court and what I teach, and you teach it too, Michael Bryant. What's the most important thing you can do about any case? Preparation, preparation, preparation. So
That is true. Can't disagree. So we'll figure out. I feel like just for sake of consistency, since we've been following Walsh and we did have some interesting stuff today, maybe I'll do a 6 o'clock. I don't know. I'm going to leave it up in the air. I don't know. I'm not committing Missy, because I think she may have something as well. So anyway, we'll if you see notice, come on by. At this point, I'm not sure what we'll end up doing. And I do want to go back through these other documents too. That
you have to go back
through.
you started going through these documents here in Walsh, and plus you had a lot going on in Mangione this week. He was sick today, so the suppression hearing did not continue today. It was supposed to
So they
continue
went 3 days this week. They were dark Wednesday, and they'll pick it up Monday. Serena Townsend, who's a friend of the network here, has been very involved in that. We're going to have her on when appropriate, when it works out.
She's great. She's great.
Yeah, you guys, I'm sure you recognize her if you don't recognize the name. And we're not sure I don't expect the court to rule from the bench after a very intense evidentiary hearing. And we've talked, in your absence, we've talked about the issues and the evidence that's been coming in, and our, my gut feeling as to what that will ultimately mean. But we play devil's advocate. What if it's not in? What if you can't get the gun in? What if it certainly would have great implications. My feeling is it's all coming in. But the analysis and the process is very interesting.
Right,
So
and the choice of law and the conflict between the laws between New York and Pennsylvania and all sorts of different things. My view is that judges let everything. My view that there is no there's one case in a million anymore you see where a search is suppressed. That judges find ways around them. They let them in. They just let them in, whether
Yeah.
it should be in or shouldn't be in, whatever what you think of somebody's guilt or not. But then of course, even if you can't get the gun in, do you get the video in? I mean, there's ways to. If you are a good prosecutor, you can try the case without some critical evidence.
yeah, you just
People
have
get
to
convicted on bullshit evidence all the time.
Of course,
Everybody.
of course, you just have to be nimble and come up with. I mean, look at the Walsh case. And thanks, by the way, Kitty Cat Naps. He said sanctions could be considered. I mean, how waffling could that be? It shouldn't be sanctions could be considered. It's like you will be sanctioned, period, if you miss these deadlines or if you somehow don't comply with the court's orders. You will be sanctioned. So we'll see. I'm not giving him a full pass, but his first day in the seat. I get it.
It's
We'll
his
see.
first day.
We'll see what happens.
I like them. I like them.
know.
My gut feeling is I like them. But let's see. You're right. Let's see.
Yeah, he's inherited a pile of crap, and so I don't blame him for that. But let's talk about the Walsh case in terms of being nimble. Do you think the prosecution, or when did the prosecution know that the defense on the first day of jury selection was going to take a deal, or not a deal, just plead guilty to two of the lower offenses? They weren't lesser included; they were the lower offenses of the getting rid of the body and lying to the cops. You got to change your whole case at that point.
Yeah, and they filed the brief that he can do that. I think was it the day before the trial started. So there must have been some discussion where the prosecution wouldn't take the deal, and then they said, "Well, we can plead guilty to
Yeah,
anything."
you can't stop us from pleading guilty. Yeah,
guilty. Yeah, and so and the judge would have to say yes. But she's really, from the dribs and drabs that I've been able to catch, she's
great.
Incredible. She's going to the
Great.
Supreme Court of that state, or the Supreme Judicial Court, as they call it, that state eventually, I think.
Yeah, she was appointed, I think, in 2000. I want to say 17, and maybe a little off there. But yeah, she's been great. It was nice to be in the courtroom with her. I'm going to go back next week. You may have heard that Proctor is testifying.
Really? I didn't. I
Well,
missed that.
here's how it unfolded.
Tell me. Oh, give me the tea. I want to spill my tea.
Yeah, I know. Missy said we're all here for you to spill your tea. So I will give you something to spill at some later date. So we're listening to. I had already said, based on the way they seem to be working around Proctor, because they had Schmidt on there for 2 days, called him the lead investigator, but he's a local cop. And then, of course, they had Keefe, who's been on there, and he's now done. And they had Guarino, everybody's favorite, was on there. So we're thinking, I'm thinking, what do they need Proctor for? Even in the audio recordings, he was a non-factor. He introduced himself. He was there, but he never even asked any questions. So I really felt like they're just working their way around Proctor because everybody does. And why wouldn't they? Well, today the court said from the bench, when talking about, I'm trying to remember the underlying issue that she was talking about. I think it had to do with either the investigation or some gathering of the evidence. It was at the time in which they were introducing all of the physical evidence, the hammer, the hacksaw, all of that stuff. And she said, I'm sure it's going to be something that'll have to be discussed even with Proctor's testimony. So, I mean, it sounded pretty clear that somebody has told her he's coming. Obviously, they could change their mind at the last minute, but I would like to be there for that. And best we can. And we think, again, because of the nature of the change in the case, and now Walsh saying, I didn't kill her, but I did disappear her, he's got to take the stand.
Well, I mean, obviously, if he had just found her in bed, people could say, you should have called, but obviously something happened that she just didn't she didn't look right unless you chopped her up and got rid of her. In my opinion, if I'm sitting there on the jury, because I haven't followed the case as much, except for the fact that didn't he do this with his kids in the house?
Well, that was a question about whether they were, like asleep in their rooms.
Geez, just let me cut the body up in the bathtub while you sleep in the rooms.
Or here's what I think happened in terms of that part of the process. In terms of that, I think that happened the next day, or even because you can look at his travels. So I think he must have had daycare for them, because we know from the police interviews, those kids are a handful. they were running around and screaming and yelling during the police interviews at his
Right,
house.
okay.
So I'm
Really?
sure
Okay.
he
Yeah,
wasn't
that's very
like,
clear, right?
okay, you guys go play. No, they were not going up 2, 4, and 6 at the time. So I'm assuming that when that was part of the crime was happening, he had them handled somewhere else. It just makes sense. Here's a theory I came up with today as I'm starting to hear more and more about the Tipton. Larry Tipton did an amazing job cross-examining Keefe. He really was good.
Tipton's a fabulous attorney. I don't know him personally. He's got a great reputation, but I've seen
I
his
said
work.
hi
He's a
for
fabulous
you.
attorney.
I said hi
And
for you.
look, he's got some of the hardest jobs you can have. I mean, he's a great lawyer.
Yeah, and his job got even harder when his client pled guilty to those 2 charges. But I don't know if you heard or not, but I meet the guy in the hallway and I followed up because we talked to him, we meaning Missy, bugged him after the McGee case. Remember the
Right.
woman who was charged
The
with the
woman,
death
right,
of her husband,
right,
and it was
right,
in front of
right.
Judge Bev, and he got an acquittal. So I just said, we wanted to say hi. We reached out at that time. I just want you to, face with the name. Here's my card. And how you doing? And he said, no comment. And then he started to walk away and he turned and said, nice to meet you. So, and this was at a time where it was not going as well as it was when he did cross-examination today, which I think was amazing. He basically was able to paint a picture for this jury that said, these folks were just normal. Look at these texts back and forth about her flight and when you're going to come in and him buying her a Porsche and kidding one another. Ha ha, this. It didn't sound at all like a couple that was on the verge of collapse. So I'm thinking something happened after the New Year's gathering, which by all accounts was fine, civil, and everybody had a good time.
Right. Didn't they make plans for another dinner?
Well, the boyfriend had a dinner planned with her for January 4th. That was going to be their New Year's Eve. Okay.
Right. Right.
So she told him at some point, I can't stay. She was going to stay till the Tuesday after New Year's. She told him at some point, I can't stay. I'm going back tomorrow, meaning that Sunday. That may have triggered some sort of discussion. And the question becomes, did he really know about the boyfriend then? That's still far from clear. And did he have suspicions? And maybe that was part of the conversation. That turns into an altercation. That gets physical. And somehow she dies in that process. Then he has to get rid of the body because proven cause of death is not going to help him. So let me ask you this, counselor.
Okay.
The lesser included, second-degree murder, heat of passion. I don't want that as the defense counsel. I want to force the jury to find the intent to murder. Because I think that's a much harder climb, and I don't think they're there yet. And it also gives them a compromise if they find that, well, I'm not sure if he intended, but maybe, that we can infer there was a fight and maybe through heat of passion that happened. It's not part of this case, good or bad, that there's no second-degree murder at this point.
Why isn't it part of this case? I mean, because if there's any implication, the judge has to charge it.
Well, they aren't there yet. I'm expecting it's going to be a discussion at some point.
Yeah. I think that if you're defense counsel, you want that in because or else they're going to find him guilty. They're not going to just say they're juries are smart. Okay, they're going to take all the stuff that he did and they're going to say, of course, he had an intent to kill her. Of course he did. And he may have formed that intent at the last second. She told him something and he just, she's going to go to the feds and dime him out on something. And he's going to, go away forever just on the Andy Warhol thieves. But I think that he gets convicted. So I want him to get convicted of the second degree because unless then you can say what we've always said was that this should be his defense. His defense was going to be that it was an accident. I got scared. And, something happened. So,
which obviously is contrary to his current story, which is,
right.
He just nudged her and she was already dead. Some sudden, sudden unexpected death.
Well, I mean, what if, we could solve that in the Scandarito, right? Except Scandarito got on the stand. We should go back and try to pull some of those and play some of that.
That's not a bad idea. If we had time to do that, I mean, but that's not a bad idea. That's not a bad.
It was a Florida case for all. He chopped up his dad. They never found the head. They put him in different suitcases, right? He said that he had an hors d'oeuvre server full of cocaine and his dad with a heart condition overdosed. All right. And he got scared he was going to be blamed. And so he went to Walmart, what is it, Walmart or
the usual round, the usual haunts.
And then all I remember saying, it was so hard to cut up the body.
It was exhausting. You almost felt sorry for the guy. You see him out there sweating away, cutting his dad up with a saw or whatever he had. He had the tarps down in the garage. He had to stop a couple times for a smoke break because he was so exhausted.
Exhausting.
Yeah.
But everyone believed that he had an hors
Yes.
d'oeuvres. Everyone in that case believed it was an accident,
Mhm.
and it was part of it. He took the stand in part because he was so real. I mean, he was so real. Walsh is not that guy. He's not
Not
scandalous
for the
anyway.
interviews. Nope, not from the interviews we've heard. We just heard him as Chatty Cathy, much more like our friend Doug Weinstein's client, right?
Oh my gosh.
Lacatus, yeah, something like that. Who was actually, I think he had a chance until he took the stand, and then he sunk his own battleship. That was nasty.
Yeah.
So we
Yeah.
expect anyway.
Doug was so good. Doug had done such a good job.
Yes, he really did. He had done such a great job of, at least taking one of the guy's feet out of the fire, and no, guy jumped right in with both feet.
See, the problem
but-
is this guy, Maz, did he know? Can they prove that he knew she had a boyfriend? Well, is there going to be evidence to infer that he knew?
There's
And
some evidence that he knew when he talked to the cops at some point, and there's some suggestion that he may have had, and we went into this conversation yesterday because I've had similar experience, where
Right.
he got texts not intended for him because of the connection of their phone account.
Right,
That's what
right,
because
right.
I have 4 phones,
And you
and I get, so if that were investigated and it came up as evidence, every place one of those phones would be my phone, even though I ain't me. And so
okay.
he was getting, and I get texts from my son occasionally that are not to me. They're
Oh, really? Okay.
And that's an Apple thing. But
Because
anyway,
they're connected. Okay. All right.
because of the connection with either the iPad, the Apple account, right?
Okay.
Anyway, so there is some evidence, and it hasn't been fleshed out yet, that he told the cops that he had gotten messages not intended for him. So there is some suggestion. That's why in my analysis, it's like either he really knew or he had a hint, and either one led to that confrontation that night.
Wasn't it though that if she lived and he got divorced, he'd be better off? Isn't there something about that? Or did I read something? I mean, so I'm like a juror. I haven't really followed the
Well, they
case,
have,
obviously,
there's
they-
some financial well-being discussion about getting a divorce. A paper divorce would be better because if he was going to go up the river to the big house and wanted to protect assets from his restitution, which is 400 to 500, as last I heard, 400, 500 grand, to protect the family, get a divorce. So that's been a discussion, not really confirmed, but it makes some of the conversation between them make some sense. Why are you getting a divorce? Because that obviously would be the first signal that, oh, there's some problem with the marriage. Why
Right.
would you be looking into that? Well, they may have had
Well,
an
I think
alternative reason.
having an affair may be an indication that there's
Well, of
there's some
course, but
problem that
that doesn't fit the defense. The defense
Right.
would be saying, no, he had another reason, a legitimate, caring reason for the family to do it.
Right.
So there hasn't been that connection.
Or it could be that, look, we had an open marriage. I didn't care what she did.
Yeah.
I knew that I was going to possibly go to jail. We had but then he's got to take the stand and he's got to sell that. That's
the bottom
question.
line.
He's got to sell all this. He's got to sell it, and he just doesn't look saleable. His attorney, I think, is really likable, but
Mhm.
from what, again, I'm only seeing tidbits, so I'm not a good judge at this point.
Well,
But he
tidbits
just
have
doesn't
tipped
look
in
saleable.
were pretty good. He's dynamic, and people are a little mad that he hovers around, and it is a podium there. So he hovers away from the podium, and obviously the sound suffers when he does. So,
Okay.
but it's part of his thing. He's very dynamic, and I think he's been fun to watch and very effective with doing what he can with what he's got. So travel arrangements, it'll depend. I'm going to try and do what I can to figure out. I mean, if Proctor is on Monday, I'm screwed because I don't think we're going to be able to pull that together that quickly. But we may learn enough on Monday to suggest Tuesday is
Okay.
the time to
It's
go.
a day. Okay.
I don't
All right.
We'll see.
Oh, we'll see. That's it. That's going to be, everyone's going to want to have, maybe they'll have a line at the courthouse for that because he has an attorney, by the way, Proctor. Proctor now has an attorney.
Oh, they found somebody.
Yeah.
Found-
Well, I assume
To
that even
appear in the federal case, right? That's the
federal case,
yeah.
case, yeah. But I assume that even though it's not even though it's not, the police union has gone away from. I'm sure it's somebody that's associated with knowing how to deal with police and all.
I heard that he does represent a number of police unions. That's what I
Right.
heard.
So
Yeah.
that's usually
So
what
everybody
happens.
deserves a defense.
Absolutely. Everyone deserves defense. I mean, and and this is a civil case, right? But everyone deserves a defense in a criminal case. I mean, look at all these people that were wrongfully convicted in jail for 40 some years, guilty, guilty, guilty. There's no doubt about it. Turns out they're all innocent, right? But people were like, well, they're terrible, they're this, that, and it turns out they're not terrible. They're not this, they're not that. The terrible people are the people that put them in jail. So everyone has to remember that. Not that I'm saying that Proctor's a good guy, okay, or somebody. I mean, I wouldn't represent Proctor. I mean, but I have the luxury of,
picking and choosing.
Cases.
Yeah,
right.
Of course. Yep, and there are folks that really kind of relish representing the less popular. Let's put it that way.
Right.
It's a challenge.
And it's a challenge, and I don't mind representing the less popular. Just some less popular people I don't like. I wouldn't represent them because I don't like them. I like to represent clients that I have. I think they have a bent in some way, a bent, whether it's they're upholding the First Amendment, whether they're upholding the Constitution, whether I think they're charged to wrongfully, whether I think they're charged with the wrong count, and or whether I think the prosecutor is just a scumbag.
Yeah, all factors. Yes.
All factors, right.
Okay, so let's get out of here, and I'll figure out whether or not to regroup for the 6th to at least go through these 2 documents we got into briefly, and then maybe some of the high points from Walsh today, because that cross-examination of Tipton, for those who missed it, it's worth the price of admission, which happens to be free. So subscribe, like, and share. Hey, see how I did that?
That's my name. Yeah. You have to hit the word. See, because I've been away for a week. He's been good. You have to hit that subscribe button. I noticed, by the way, that we've gained 1 subscriber since I left. 1. Now, of all of you here who are chatting are subscribers because you.
Yeah, isn't that crazy? That
right.
I've reminded folks
right?
to make sure that if they've subscribed before, double check. Because there has been some
people that get knocked off,
YouTubery happening. Yeah,
right. But if you're just here and you're lurking, please hit that subscribe button. People work awfully hard, very hard. Missy, all of our mods, give the channel a boost, and then comment. You can comment even when we finish. Comments get us into the algorithm. And I just saw Joy. No, Spectre was one of the best clients I've ever had. Listen to everything I've ever said. He was not scary. I was not afraid of him. He was a terrific client. I have no problem with Phil Spector. I've had clients that look like they have a great attitude outside who are not Phil Spector. He was fine. And his daughter, I'm still friends with. Okay, so that's the answer to that question.
All right, then. So do whatever those things were that she said. We had some new members that signed up last night, even during the members only, which was interesting. They're just like new people were just popping on. It was great. So, okay, then,
yes,
yeah.
We gained quite a few new members, but we need also subscribers besides members. We need both. So all of you, please just help us. A little Zen help. A little Zen help. Okay. Make me feel wanted.
There you go. And if you folks can't make it back for tonight, we get it. You need some time off. I feel like just wrapping things up in a bow since we've been doing this all week. So I probably will come back for some purpose on 6 o'clock. You'll see the notice, and we'll finish off the week in some sort of style. All right, then.
Then we'll see you Monday.
All right. In the meantime, try to do the right thing.
On the sky.